Hello everyone, my name is Megan Armstrong and I'm a solicitor at Michael Lynch Family Lawyers. As many of you might already know, Michael Lynch Family Lawyers is a Brisbane-based law firm and we practice solely in family law only. We're made up of 12 solicitors and some of those are accredited family law specialists. We work with clients who are at all different stages of a marriage breakdown or their de facto separation, and we work with them with their subsequent property settlement and parenting issues which flow on from their separation. As counsellors, I'm sure many of you will understand, this type of work means that we have many clients who are experiencing or have experienced or are at risk of experiencing family violence, which is of course the topic of today's webinar. Family violence has been the forefront of the media coverage as of late. So across Australia, police are called out to domestic and family violence incidents once every 2 minutes. On average, Queensland Police respond to 260 domestic and family violence occurrences each day. But we know that these statistics don't even accurately reflect all incidents of family violence, because the unfortunate reality is that there's a lot of family violence which happens behind closed doors and that isn't reported. So due to the work that we do as family lawyers, we often see family violence escalate during the time of a separation, and particularly if there are court proceedings required to deal with parenting arrangements and finalising a financial separation. So that's why we're dedicating this webinar to family violence from a family law perspective. And we'll be looking at how the Family Law Court of Australia and the Federal Circuit Court deal with this very sensitive topic. So as you can see on the screen, today's presentation will cover the following questions. So what family violence is under the Family Law Act, how the Family Court addresses family violence, what the court's best practice principles are for assessing the risk of family violence, what practical steps the court takes in relation to family violence, what are some of the new approaches that the court's adopted to deal with family violence, and lastly, what is the Lighthouse project? This presentation isn't about domestic violence under the Domestic and Family Violence Protection Act, and it's not going to be about getting a protection order. So our focus today is on family violence under the Family Law Act and what happens when family violence is combined with parenting and financial issues as a result of separation. In saying this, if you or anyone of your patients or anyone you know need advice about making an application for a protection order, by all means, please don't hesitate to contact our office. We've also previously done a webinar specifically in relation to domestic violence and protection orders, and this is available on our website. So just by way of a brief history, about family violence, the Family Law Act was amended in 2006 to include family violence as a relevant consideration in parenting matters. Then in 2012, the definition of family violence under the Family Law Act was broadened to incorporate the notion of coercion and control. This was a significant change because, as we know, coercion and control are not always accompanied by physical violence or threats. So without these behaviours specifically provided for under the Act, coercion and control would not otherwise be recognised as family violence. From a more practical point of view, it's important that anyone going through a family law separation understands the definition of family violence, as this could have a big effect on their parenting matter and also their financial settlement. So it still surprises me when people walk through our doors and make a comment such as, oh, I didn't see that there was anything wrong with that behaviour, or I didn't realise that that level of control would constitute family violence. So it is often that we are going through this definition with our clients. So what is the definition of family violence under the Family Law Act? So family violence means violent, threatening, or other behaviour by a person that coerces or controls a member of the person's family or causes the family member to be fearful. The Family Law Act also includes examples of behaviour which are not necessarily any sort of exhaustive list, but it just provides a guidance as to the types of behaviour that might constitute family violence. So this includes those set out on your screen, which is assault, sexual assault or sexually abusive behaviour, stalking, repeated derogatory taunts, intentionally damaging or destroying property, intentionally causing death or injury to an animal, unreasonably denying the family member the financial autonomy that he or she would otherwise have had, unreasonably withholding financial support needed to meet the reasonable living expenses of the family member or his or her child at the time when the family member is entirely or predominantly dependent on the person for financial support, preventing the family member from making or keeping connections with his or her family, friends or culture, or lastly, unlawfully depriving the family member or any member of the family member's family of his or her liberty. So again, this is not any sort of exhaustive list. If there's conduct that's not described in this list, the court can still definitely consider it as family violence. So a child is exposed to a family violence if the child sees or hears family violence or otherwise experiences the effects of family violence. Now, that statement might sound quite broad, so the Act has given some examples of situations that may constitute a child being exposed to family violence, and again, this list isn't exhaustive. So those examples of situations include where the child might overhear threats of death or personal injury by a member of the child's family towards another member of the family, seeing or hearing an assault of a family member by another family member, comforting or providing assistance to a family member who has been assaulted by another member of the child's family, cleaning up a site after a family member has intentionally damaged property, or being present when police or ambulance officers attend an incident involving the assault of a family member by another family member. So again, this isn't an exhaustive list, but it just gives you an example of some of the scenarios that the court would consider constitute a child being exposed to family violence. So now that we've addressed the definition, how does the court address family violence? Firstly, the Family Court and the Federal Court of Australia have in place a family violence plan, and this sets out a comprehensive set of measures which are aimed to support people who are experiencing or are at risk of family violence. The family violence plan is used by administrative staff, decision makers, legal practitioners, service providers, and anyone else involved in the overall family law system, or anyone dealing with family violence. So the family violence plan is something that you all as counsellors can look to for guidance when dealing with patients that are experiencing family violence and have court proceedings on foot. Some of the measures that are set out under the Family Violence Plan include a regular review of the family violence best practice principles, which I'll come back to in a moment, a regular review of the operational and administrative processes of the courts in relation to family violence, ongoing training and development of staff to enhance awareness and capability in addressing family violence issues. And also the last measurement is to improve communication of the court's response to family violence. So the Family Violence Plan refers to a family violence committee, and this committee is made up of judges and other members of the court, and they're responsible for actioning the measures set out in the plan. As mentioned before, there is the Family Violence Best Practice Principles, and this is a checklist of matters to which judges, court staff, legal professionals and litigants can refer to at any stage of the case management process for disputes involving children. The best practice principles are applicable in all family law cases involving family violence or risk of family violence. I'll go into them in a bit more detail when we look at the best practice principles in a moment in relation to assessing the risk of family violence. It's important to note that the Family Law Act doesn't require independent verification of allegations of family violence for the court to be satisfied that that family violence has occurred. This means that they don't necessarily need evidence by way of, say, a police report or medical records to be satisfied that there's family violence involved in a matter. So in the 2009 case of Amador and Amador, the family court said, where domestic violence occurs in a family, it frequently occurs in circumstances where there are no witnesses other than the parties to a marriage and possibly their children. We cannot accept that a court could never make a positive finding that such violence occurred without there being corroborative evidence from a third party or a document or an admission. So this is great that the court has recognised that the victims of domestic and family violence shouldn't have to complain to authorities or subject themselves to medical examinations just to have their evidence of family violence accepted. However, despite me saying this, and from a more reality point of view, to persuade the court to actually make orders in relation to the care of children and to make orders that are appropriate in the circumstances of family violence. Supporting reports and evidence from third parties are often relied on. Otherwise, it just ends up being one party's word against another. So we often rely on subpoenaed material, and I'm sure as counsellors, the concept of subpoenas is definitely nothing new to your ears. So a party to a court proceeding can subpoena a third party to produce documents to the court. It might be helpful to subpoena, for example, records from their treating medical practitioner, a psychologist, their counsellor, the police, the Department of Child Safety, or even a child's school. If a party has reported family violence to that third party that is then subpoenaed, those records will support the court making an order that reflects the need to protect the child from family violence. So, parenting cases considering family violence, that's what we're going to look into now. When the court's considering parenting cases, the best interests of the child is the primary factor to be considered. And the court says that ensuring the safety of a child is central to all determination of what's in a child's best interests. The Family Law Act says that the court must apply a presumption that it is in the best interests of the child for that child's parents to have equal shared parental responsibility. This means that the parents must make joint decisions in relation to the major long-term issues which are affecting the child. And major long-term issues are things like education, health, and religion. But each parent can still make their own decisions about the child's day-to-day care. So decisions about what the child's going to wear or what he or her is going to eat for lunch. The interesting thing about the presumption of equal shared parental responsibility is that it doesn't apply if the court is satisfied that it wouldn't be in the best interests of the child for the parents to have equal shared parental responsibility. And this is the case if there are reasonable grounds to believe that there has been family violence. So in that case, if there has been family violence, the court may decide that one parent has sole parental responsibility, which essentially just means that that parent with sole parental responsibility can make unilateral decisions about all major long-term decisions for the child, so health, education, and religion. When making a parenting order, the paramount consideration for the court is the child's best interests. So in deciding the arrangements that will promote the best interests of a particular child, the court must consider two primary considerations under the Family Law Act, and they may also consider an additional 14 considerations. One of the primary considerations is the need to protect the child from physical or psychological harm from being subjected or exposed to abuse, neglect, or family violence. As I'm sure as counsellors you'll appreciate, there can be a tension between these two different considerations, but the Family Law Act says that the greater weight must be given to the safety of the child above all other considerations. Now, I'm going to touch on the economic and financial abuse for the purpose of looking at how the family court considers family violence for property settlements. So economic and financial abuse is a pattern of behaviours used by perpetrators to exert control over the victim, usually by excluding the victim from decisions about finances that affect the victim, or controlling their access to finances and income. So in speaking with clients, it really shocks me the number of people who may not have access to their own joint bank accounts or are given a small weekly allowance from their spouse, or maybe they don't even have access to an account at all, they just have a credit card. This is particularly concerning where that party doesn't work, and so they're completely reliant on the perpetrator to provide them with financial support. It's been reported that a lack of financial independence is a primary reason that many victims don't leave abusive relationships. Unfortunately, as we see in many cases, economic abuse can continue on even after the parties have separated. Often this will include things like, for example, the husband cutting off the mortgage repayments to the former matrimonial property, even while the wife and kids are still living there. Or by way of another example, where one party stops paying necessary bills that they had otherwise agreed to pay, and then the other party is relying on them to pay, so bills such as an electricity bill or car rego. So the former spouse is burdened with the stress of these being left unpaid or overdue. Behaviours which sabotage the victim's employment may also constitute economic abuse. So unfortunately, we have seen many cases where a perpetrator prevents the victim from leaving the house for work or for job interviews, or they harass the victim at their workplace, so much so that it results in the victim being terminated, their employment being terminated, or their work hours reduced. When the parties then look at doing a property settlement and are trying to figure out what they might be entitled to, One of the steps to consider is the contributions that have been made by each party to the property pool. So what happens if one party hasn't been able to contribute as a result of family violence? Well, the court recognises the relevance of family violence, which has impacted on the victim spouse's ability to contribute to the acquisition and conservation of property, to the extent that it has made those contributions significantly harder. When the court is prepared to consider family violence in a property settlement, it's referred to as a Kennan adjustment. And this is named after a case where the victim of domestic violence was actually awarded a greater part of the property settlement. For this adjustment to be made, the court has to determine that it was significantly more arduous for that person to contribute to the relationship due to the violence that they suffered. Now, what are the best practice principles for assessing the risk of family violence? The best practice principles recognise 4 categories of family violence, which you'll see on your screen here. So firstly, coercive controlling violence is an ongoing pattern of where a party uses threats, force, emotional abuse, and other coercive means to unilaterally dominate a person and induce fear, submission, and compliance in them. The focus here is on the control, and it's really important to understand that this category of family violence doesn't always involve physical harm. The second category, violent resistance, is a category of family violence which occurs when a partner uses violence as a defence in response to abuse by a partner. It's an immediate reaction to an assault and is primarily intended to protect oneself or others from injury. Thirdly, situational couple violence is partner violence that isn't necessarily based on a dynamic of power and control. So generally, situational couple violence results from situations or disputes between partners that escalates into physical violence. Lastly, separation instigated violence is violence which arises as a result of separation and where there was otherwise no history of violence in the relationship. So assessing the type of violence that has been perpetrated by one party on the other assists the court to identify violence that represents a real threat to the well-being of a child. The ability of a court to determine the future impact and the magnitude of risk of exposure of family violence on the children is going to be influenced by the categorisation of the violence to which any child has been exposed in the past. The best practice principles set out a range of considerations which are important when making interim orders. And so interim orders are orders which only really apply until the final order is made. At the forefront of the decision maker's mind when making interim orders is what the likely risk of harm to the child is if an interim order is made for the child to spend time with a person against who allegations of family violence have been made. In terms of final orders, the critical importance to decision makers are the considerations of how the children have been affected by exposure to family violence and what measures can be taken to ensure their future safety. The best practice principles uses a framework of factors to look for when considering the risk of family violence. The PPP method assesses risk of screening for the potency, the pattern, and the primary perpetrator of the violence. The potency of violence this assesses the level of the severity, the dangerousness, or risk of lethality. The pattern of violence analyses things like repeated and unwanted attempts to contact the ex-partner, especially for the purpose of controlling and harassing them. This element also considers the history of physical violence, threat making, disregard for authorities, and it looks at how fearful or intimidated the other party is. Lastly, primary perpetrator indicators are particularly relevant where it's a matter where it's one party's words against another. So this requires a consideration of which party provides a more clear, specific and plausible account of the violent incidents. It also looks at the size and strength of each party and the motives that are used to explain why the incidents have occurred. There's a number of practical steps that the court takes in relation to family violence, and I'm going to go through those practical steps now. So to commence court proceedings in relation to parenting matters, it's usually compulsory for parties to participate in family dispute resolution. You might have heard the term a Section 60I certificate being used, and this is the certificate that's given when the parties have attempted to participate in family dispute resolution. Where there's family violence involved, it isn't required. Family dispute resolution isn't necessarily required if the court is satisfied that there are reasonable grounds to believe that family violence has occurred. In parenting matters also, where there's an allegation of family violence, a party can make an application to have an independent children's lawyer appointed. So the role of an independent children's lawyer, which we shorten to be ICL, which you may have heard of, their role is to represent and promote the best interests of the child. Another practical step is the safety planning when attending court in person. So if a party has concerns for their safety, it's really important that they let the court know before attending a court event in person. This can also include requesting that a party be excused from appearing in person, and the court may give them leave to appear by electronic means instead. This hasn't been very necessary over the last 12 months because most court events have been conducted by telephone or Microsoft Teams, but it is important that people are aware of this option for when attendance in person becomes the norm again. Lastly, another practical step taken by the court to address family violence is prohibiting cross-examination between self-represented parties when there has been family violence. So cross-examination is where one party sits in the witness box at a trial and is asked various questions about their evidence. The questions would usually be asked by a barrister, but where one party is self-represented, or if both parties are self-represented, the other side will be responsible for asking the questions under cross-examination. In our experience, victims of family violence often make for somewhat traumatised and vulnerable witnesses. So it would be even more stressful experience for a victim of family violence to be cross-examined by someone who has perpetrated violence against them. So this is where Section 102 NA of the Family Law Act steps in. Now, under this section, the court can make an order preventing the perpetrator from personally cross-examining the other party. Legal aid has been given specific funding to provide legal representation to people where a ban on personal cross-examination has been made. Interestingly, access to this scheme isn't limited to the party's financial circumstances or the details of the case, as legal aid representation would usually be, but the party may be asked to contribute to the costs of the legal representation if they have an ability to do so. So unfortunately, as we know, COVID and the associated lockdowns caused a significant spike in demand for domestic violence services. So a person can make an application to the COVID-19 list and have it urgently heard if there has been an escalation or increased risk due to family violence associated with the COVID-19 pandemic. For example, this would apply if, say, there's been a breach of a family violence order, a party's been charged with a family violence order related offence, or the recent involvement of a child welfare agent in relation to family violence concerns. Now, in relation to the Lighthouse project, the Family Court and Federal Circuit Court in Brisbane commenced a new pilot program called the Lighthouse Project, and this is going to be trialled for 3 years. The program has been designed and introduced in an effort to protect families involved in parenting proceedings from family violence as well as other safety matters. Once the court application is filed for parenting proceedings, the parties can be invited to complete a confidential online risk screening assessment called the Family Doors Triage. Now, DOORS, if you're like me and was wondering what it stands for the Detection of Overall Risk Screen. The service is focused on early risk intervention and identification and responsiveness to those risks. The results from the screening process are then considered by registrars and family counsellors with the assistance of case managers and case coordinators in the court, and they determine how the case will then be managed. There are 3 possible pathways for the management of cases depending on the level of risk identified. So if it's identified as being a high risk case, it will receive early attention by means of an appointment with a family counsellor who will then conduct a follow-up risk assessment, develop a safety and wellbeing plan, and offer referrals to support services. A registrar of the court will also review the case to determine if it should be referred to the EVIT list. So the EVIT list is a new court list that has been introduced as part of the Lighthouse project. When the court considers whether a matter is appropriate for the EVIT list, the registrar considers whether the proceedings have a high risk factor, which includes serious family violence or risk, or serious family violence by a party to the proceedings, whether it be physical, emotional, psychological, or financial. If the matter has been identified as being one with a moderate risk, the parties will be offered safety planning and service referrals, and consideration will later be given to other case management options, such as court-ordered family dispute resolution. Lastly, if the case is categorised as a lower risk case or a green light case, then the parties will just proceed as normal, with the focus being on court-ordered family dispute resolution. I do have some practical tips that I want to provide to you before we wrap things up for the webinar. So these practical tips I've sort of come up with on the basis that if you're talking to patients and they raise concerns in relation to family violence, these might be some things that you could pass on to them. So particularly in relation to parenting matters, it's important that parties that are experiencing family violence set some boundaries in relation to communication. So they could request that their former spouse only communicate with them in writing, so either by text message or by email, unless in the case of an emergency regarding the children. This setting boundaries with communication, it's important to stop the constant abusive phone calls and that sort of thing. In relation to changeover with children, often we do hear that that's where issues arise between parties where there's family violence. So if possible, it's best if they limit the direct contact with the former spouse, and maybe they should suggest doing changeovers at a school, or if it can't be at a school, if the children aren't of an age where they're at school, or it's a weekend or school holidays, then at a public place, such as, for example, a car park to the shopping centre or the local McDonald's. So The beauty of changeover through school is that if one party drops the child off on a Monday morning and the other party picks them up on Monday afternoon, they can avoid all contact. I guess if a school changeover isn't possible in a public place is important, the parties should avoid, wherever possible, allowing the former spouse to come to their house or going to the former spouse's house. If there is really high conflict between the parties and changeovers are causing additional abuse or incidents of family violence, they could possibly look into getting someone else to do changeover on their behalf. So if there's a grandma or grandpa or other family member, such as an auntie or uncle, that could attend changeover with the kids. Or as a bit of a last resort, changeovers could also happen at a contact centre. So they walk in with the kids, drop them off in a room, and the other party comes and collects them, and it's all supervised by the contact centre. The contact centre can also make notes, so if there's any issues or incidents, they can record this. Speaking of keeping a record, it's really important that people that are going through a separation and there's family violence, it's really important that they keep a diary of any incidents and they note down what happened and on what date. So if there's a particular argument or they're being abused on the phone or something like that, jot down the date and what the other person said, what names they were called, those sort of details. That's just very helpful if it does come to court proceedings. When we're drafting affidavits for clients, we often are instructed that they're always being abused on the phone, but the affidavit can be a lot more, a lot stronger and more detailed if we can say on this date he rang and called me XYZ or something like that. It just supports their case a lot more. In relation to property matters, again, it is best to communicate in writing only if possible. So not to be negotiating by phone, because the other party might then deny having said something or spinning it in such a way later. Whereas if the record's always in writing, the client can always refer back to it. One of my hot tips in relation to property is that if a person is still going through the separation and considering leaving the former matrimonial property, it's important that they take their personal possessions with them. So this is things like photos, clothing, passports, just all that sort of important documentation. So even in straightforward matters, it's really hard for clients to get back their personal possessions on an interim basis, and they could be waiting a very long time to get final orders. So if especially where there is family violence, it's probably going to be even harder to get back their possessions. So that they should really take this with them from the start. My other tip in relation to property matters, if there are joint accounts, you could recommend to your patient that they put joint signatories on those accounts to minimise any significant problems with money being transferred out. It's important to recognise that if you or anyone if one of your patients are experiencing family violence, I urge you or them to reach out for support. So in addition to the legal channels that we've covered today, the phone numbers for 1-800-RESPECT and the DV Connect women's line and men's line are on the screen. And that does bring us to the end of the webinar. But if you have any questions about anything that I've spoken about, please don't hesitate to contact me. Our office contact details are, of course, on the screen. Alternatively, if you have a patient who you think might benefit from having an initial consultation with us, you're welcome to give us a call on their behalf or pass on our details to them, and we would be happy to talk. Thank you very much for joining the presentation today, and I hope that you've learned something useful from it. Thank you.